We're live. Okay, welcome back, folks, to House Human Services. We are now going to undertake a hot off the press from House Commerce walkthrough of S-198, which we will take possession of this afternoon when Commerce refers it to us. And we are very fortunate to have Budget Counsel Jen Carby here, who has been busy working on this bill. So thank you, Jen, for being here.
Sure, thanks for having me. For the record, Jen Carby, Office of Legislative Counsel. And I am here with as the chair said, hot off the press, House Commerce Strike All Amendment to S-198, which is an act relating to the regulation of tobacco products and tobacco substitutes. I will put this up on the screen.
It is on our members. You can find it on our website as well.
If you're interested in what changes House Commerce made from what the Senate passed, I can share the markup version on their website, but probably.
Actually, it probably would be helpful, I guess. But also just kind of run through whatever.
We'll go through this, but if anyone would like to see it or you want to focus on anything. And I will flag there's one particular area that was punted to your jurisdiction. So I will mention that when we get there. So this is S-198, as I mentioned, and we start out with much of the bill is amending 7 VSA Chapter 40 on tobacco products. Starts out with some amendments to the definition of tobacco substitute, which for anyone who wasn't here the last time this committee worked on tobacco stuff is the statutory term for e-cigarettes and a number of other items, but that's kind of where it grew out of. So as amended, this definition would say tobacco substitutes means any product that meets all of the following conditions. First, the product is manufactured from, derived from, or contains tobacco or nicotine, whether natural or synthetic, including nicotine alkaloids and nicotine analogs. The product is intended for human consumption by smoking, chewing, inhaling, sucking, absorbing, or consuming in any other manner. And the product is not a tobacco product, which is also defined in this section. So trying to separate out things like cigarettes. The term tobacco substitute includes, and now we get into the existing definition, electronic cigarettes, and it has said or, but probably should say and. So electronic cigarettes and other electronic or battery-powered devices that contain or are designed to deliver nicotine or other substances into the body through the inhalation of vapor and have not been approved by the U.S. Food and Drug Administration for tobacco cessation or other medical purposes. And then this would add to that existing language. The term also includes nicotine pouches and any liquids, whether nicotine-based or not, and delivery devices sold separately for use with a tobacco substitute. And then it carves out as an existing law cannabis products because they are separate and also products that have been approved for by the FDA for tobacco cessation and other medical purposes. Then we have a number of definitions that are really being brought over from Title 32 right now, and you'll see this reflected in a few places in the bill. Right now, wholesale tobacco dealers are licensed through the Department of Taxes, and this bill would move that regulation of wholesale dealers and licensure of wholesale dealers to the Department of Liquor and Lottery, which is where retailers are regulated. So this change doesn't take effect right away. It would be in July of 2027. You'll see that in the effective dates. But part of what we're doing is adding some definitions that come from Title 32 with minimal modifications, mainly either updating language to use non-gendered terms and things like that, or just reflecting that it's going in this chapter and not Title 32.
And Jen, will you say again, it's going from where to Liquor and Lottery?
From Department of Taxes.
Okay. Okay.
And it is my understanding that all of the parties, that both departments are supportive of that change, but just with a 1-year delay to allow them to work out some of the details.
Okay, thank you.
So we have definitions of licensed wholesale dealer, a wholesale dealer, and maybe it makes sense just because the term comes up to look at that one a little bit, although again, not a new concept to the statutes, just new to Title 7. A wholesale dealer is someone who imports or causes to be imported into the state any cigarettes, little cigars, roll your own tobacco, snuff, new smokeless tobacco, or other tobacco product for sale or who sells or furnishes any of these to other wholesale dealers or retail dealers for the purposes of resale, but not by small quantity or parcel to consumers of these products, so not a retailer.
What is new smokeless tobacco referring to?
I think is that like dip chew stuff? Yes, I brought,
Is that like Zyn?
but I'm going to refer to my colleagues on the side of the room
Okay.
from Liquor and Lottery and the Attorney General's
Okay,
office.
well, we can
Based on your
ask them when we
questions.
have them testify,
Okay.
so, okay.
Yes, they can tell
Thank
you
you.
more about the specific products. Okay, so then we get into some changes to the licensure requirements for retailers. So the first thing we're doing is specifying that the existing licensure provisions in this chapter in Title VII are for retailers, retail sale, because of the addition of the wholesaler language. And so in general, no person shall engage in the retail sale, this is existing law, of tobacco products, tobacco substitutes, or tobacco paraphernalia in their place of business without a tobacco license from the Division of Liquor Control. And then if they want to sell tobacco substitutes, they also need to get a tobacco substitute endorsement. This next change is updating some language from the existing statutes. The existing statute has tobacco licenses and the tobacco substitute endorsements expiring at midnight on April 30th of each year. But that is reflecting a much older state of affairs and has issued across their license types, including liquor licenses. The department issues licenses to be valid for 1 year from the date of issues. This is updating the statutes to be consistent with that. And then the next several changes in this section are about decoupling liquor licenses from tobacco licenses. So there are ways under current law where someone who wants to sell both liquor and tobacco can get the license kind of together. And this separates those, and you'll hear from some of the witnesses the rationale. But first, for that, the application forms, it removes language saying that these will be incorporated into the liquor license forms and applications. Second, it strikes out references to liquor licenses and combination liquor and tobacco licenses from the scope of this section, and really allows the licenses for liquor licenses to be handled under those chapters and a few applicable chapters in Title VII, and allows tobacco licensure to be under the tobacco statutes in this chapter. And then in subsection D, there are some changes around the fees that get paid. Under current statute, a person would apply to the legislative body of the municipality where they want to sell tobacco, and pay fees. It talks about paying to the Division of Liquor Control, the applicable liquor license fee. Again, this is looking at decoupling those. And then the language says that they would pay certain fees to the legislative body of the municipality, which then would forward that fee on to the Division of Liquor Control. Now that everything is being applied for and paid online, we don't need to do the money changing so many hands. So in practice, the funds get paid directly to the Division of Liquor Control. So this is reflecting that the money now goes directly to liquor control and not to the legislative body of the municipality. But it also increases these fees. So I want to make sure you're seeing that as well on lines 15 and 17. The fee for the tobacco license now in 16 would go up from $110 to $150. And for the tobacco substitute endorsement from $50 to $75.
You can go ask first. Go ahead, Representative Bishop.
I'm sorry, I'm not sure that if I follow. Currently, are fees received and held by a municipality or received and passed along?
So under statute, they're supposed to be received and passed along, but the way the systems work, and Liquor and Lottery can tell you more about the actualities, but my understanding is the way the systems work now, it doesn't make the stop at the municipality only to go to liquor control. It just goes directly to liquor control.
Oh.
So this is making the statutes reflect the practice.
Thank you.
My question was, so I'm trying to understand, so the tobacco license, it's specifically referred to a license, and then the substitute endorsement. So it's not a separate license, it's kind of like an add-on.
Add-on, right. So somebody would have to get a tobacco license in order to be able to get the tobacco substitute endorsement.
Well, I'll ask them that. It doesn't seem like people sell only one or the other generally, but we'll take testimony from liquor and
But just to
lottery.
clarify that, Jen, you can't have the endorsement without the actual license.
Farming with, yes, that was my understanding, but yes, you have to get the license and you can get the endorsement on top of that. And I can see on my screen that Representative Steady has her hand up.
Oh, okay, I can't see that, so thank you, Jen. Representative Steady, go ahead.
I'm curious, why the increases in fees when businesses are struggling paying taxes and bills and everything?
I will let other witnesses give you their rationale on that. I think part of this is simply that it's been a while since these were increased, and this was an inflationary increase. The bill as introduced would have increased these to $1,000 each. And there was talk in the Senate about reducing that, and so they settled on going from 110 to 150 and 50 to 75. I will let others talk to you about.
Especially businesses that got stuck with that 13.9 yield bill that was overrode. They're already still struggling. So I'm just trying to think of the business owners. Thank you.
Okay, thank you.
Right.
Jen.
And so again, carrying out the rest of this change from the municipal clerk's forwarding fees to the commissioner for deposit in the Liquor Control Enterprise Fund, instead saying the fees collected, which would now be collected by the Division of Liquor Control directly, would still go into that same Liquor Control Enterprise Fund.
But it still has the application being done at the municipal level.
Yes, and the application does still get done at the municipal level.
Okay.
And
I realize all my questions are not for you, Jen, so I'm like,
that's okay, you got the right people in the room to answer them after me. so.
they will, yeah. Okay, thank you.
All right, next we have the penalties for sale without a license. And so this is increasing the penalty amounts for this and changing it from a misdemeanor to a civil penalty. Someone I was supposed to change, and I'm looking back at, anyway, think about it, talk amongst yourselves. So under current law, somebody who sells without a license is guilty of a misdemeanor and fined not more than $200 for first offense and not more than $500 for subsequent offense. As modified, this would have them be instead subject to a civil penalty, and it would be not more than $2,000 for a first offense and not more than $5,000 for a subsequent offense. So increasing the penalties for for sales without a retail license. Then it expands the prohibition on sale without being a license under existing law, no person can engage in the retail sale of all of these items unless they are a licensed wholesale dealer or purchase them from a licensed wholesale dealer. And this adds also that you cannot import, distribute, or wholesale sale or any combination without purchasing them, without being or purchasing from a licensed wholesale dealer. And it takes out the reference to the definition in the tax statutes because the definition would now be in the tobacco statutes. Now we get to, on page 6, the license required for wholesale dealers. Again, this is largely moving the language as it is in Title 32 over to Title 7. A few differences to highlight. One is that there are 5 different sections in Title 32 that deal with these various pieces of the wholesale dealer license, and I combined them into one single section and just gave some subsection headings to indicate what the substance is of those. And made, obviously the updates to the cross references to be consistent with references to this chapter as opposed to the references coming out of Title 32. But a big change is that there is a license fee. Under current law with the tax department, a wholesale dealer is not charged for a license, and the license is good indefinitely as long as they continue to operate out of that same location, same outlet. This would require the licensing fee of $1,245, which aligns with the license fee for the liquor wholesalers, and it would be required annually for each outlet. So it imposes a license fee and it requires it to be renewed annually.
Go ahead, Representative Middleton.
Within this section, and might be a question, but so any retailer within the state of Vermont must purchase all their tobacco products from a wholesale outlet? Is that what I'm reading here?
That is my understanding, and that is, I think, part of the goal of this bill is to tighten that up more. You'll see some of those changes coming up as well. But yes, and that's partly because that's how the tax gets collected, and there it can be assurance that it has been paid. Yep. All right. Also, penalties for sales without a license have been increased to align with the increased penalties for the retailer sale without a license. And so this would have any wholesale dealer who sells, offers for sale, or possesses with intent to sell these items without first getting a license would be subject to a civil penalty of not more than $2,000 for the first offense and not more than $5,000 for each subsequent offense. And this adds the expiration date that the license would be good, just like for the retailer, it's valid for 1 year from the date of issue. Okay. Now we move on to section 1005. This is the purchase, use, and possession provisions. And so this is eliminating the prohibition on, under current law, a person under 21 years of age is prohibited from possessing, purchasing, or attempting to purchase tobacco products, tobacco substitutes, or tobacco paraphernalia unless they work for a retailer and they're selling them and they're possessing them in the course of their employment, or they are in possession of the items in connection with indigenous cultural tobacco practices. This would strike that prohibition. So, and I'm sure you'll hear plenty more testimony on this with the explanation of the rationale. There's also, under existing law, a prohibition on someone under 21 years of age misrepresenting their age to purchase or attempt to purchase tobacco products, tobacco substitutes, or tobacco paraphernalia. It strikes language saying that somebody who possesses these in violation of subsection A would be subject to having the items immediately confiscated and subject to a civil penalty of $25 brought in the same manner as a traffic ticket, so through the Judicial Bureau. This in particular was where some of the conversation downstairs was kicked to this committee to consider. I know there was interest in that committee, and there may be in this one as well, about how to address the desire to be able to confiscate these items if you are not prohibiting their possession. So I'll just flag the confiscation issue for, and you'll, I think, probably hear more about it from other witnesses or from the reporter from that committee, but concerns around confiscation without a ban on possession. And then it does retain the penalty for an individual under 21 years of age who misrepresents their age by using false identification. And it increases the penalty from $50 to $100. It maintains the option of 10 hours of community service or both. And it specifies that as under the previous section, an action under this section shall be brought in the same manner as a traffic ticket, which I believe is currently the case, although it is not there was a question.
Just a question up at the top. So where you're talking about, so a person would need to be 21 years old to sell tobacco products?
No, this is all about purchasing. And the exception here is saying under, and I'm just telling you what's in the existing law that it'd be proposed to be repealed here, but under existing law, a person under 21 years of age is prohibited from possessing tobacco products, tobacco substitutes, tobacco paraphernalia, but there's an exception for somebody who works for a tobacco retailer. They work for the convenience store, they can sell them in the course of their employment.
And that's not changing.
Well, it's not changing in the sense that it still isn't prohibited, because there would be no prohibition on a person under 21 years of age possessing at all, whether in the course of their employment or not in the course of their employment.
Thank you.
Yep.
We spent a lot of time on this section in
I know.
S18. Okay.
Yes, so this will be, I'm sure, a topic of continued conversation in this committee.
Oh, it will be. Okay,
Another question coming.
I don't think so. Thank you.
All right, then we had section 1007 around furnishing tobacco to individuals under 21 years of age. And I'll just note, for the most part, I'm trying to change person to individual when it's clear that we only mean a human being as opposed to a potential for corporate entity. So it'd be an individual under 21 years of age. We're talking about who would be having tobacco furnished to them. But that distinction does matter a bit in this next subdivision, because this is really talking about the clerk. So under current law, a person who could be an individual or a corporate entity, based on the language here, but with a caveat, who sells or furnishes tobacco products, tobacco substitutes, or tobacco paraphernalia to someone under 21 years of age is subject to a civil penalty. This would increase the lower limit, the floor from the top for the first offense, not more than $150 for the first offense, and not more than $500 for any subsequent offense. And this is brought in the same manner as a traffic violation. So again, through the Judicial Bureau, my understanding, and you can ask more questions of the regulators after me, but is that this penalty is assessed on the clerk. That is how something brought through the Judicial Bureau, like a traffic ticket, is imposed. And so this reflection, that language is reflected here by saying an individual who does the selling would be subject to the civil penalty. But that is a change from how what the language currently means as far as the use of person. So I think from a practical standpoint, it's reflecting what happens operationally. But I know there's some concern among some of the stakeholders about specifying that is on the individual, although I believe that is how it's carried out in practice.
Okay, thank you. Go ahead.
Are there
And then
any
there's more.
subsequent provisions that would hold a retail
Oh, yeah,
establishment?
we're getting it. Yeah. So then we're specifying, in fact, we're sort of giving a little preview here. In addition to the civil penalty imposed against an individual for a violation under subdivision 1, for any subsequent violation, the licensee may be subject to an administrative penalty and license suspension or revocation as set forth in subdivision B2. Subdivision B1 talks about compliance testing, and that really changes here, but I just wanted to flag for you what is in here, which is that the Division of Liquor Control is required to conduct or contract for compliance tests of tobacco licensees as frequently and comprehensively as necessary to ensure consistent statewide compliance with the prohibition on sales to individuals under 21 years of age of at least 90% for buyers between 17 and 20 years of age. And it gives the okay for someone under 21 years of age to participate in a compliance test and purchase because they're working with the department. Then subdivision B2 says any violation by a tobacco licensee of subsection 1003A, which is the prohibition on selling to minors, of this title or this section after a sale violation, so a repeat violation, or during a compliance test. And under current law, that's only a compliance test conducted within 6 months after a previous violation. This would strike the 6 months and just be any compliance test after a previous violation would be considered a multiple violation and would result in the following administrative penalties and minimum license suspensions or revocation, in addition to any other penalties under this title. And then some of these are changing. Some of them are getting some clarification. So under current law, the violation for 2 violations, there is, because the lead-in language says minimum license suspensions. So 2 violations is 2 weekdays. So this is specifying that that's 2 consecutive weekdays. And it's adding an administrative penalty of not less than, so a floor of $1,000. For a 3rd violation under current law, it's a 15-day suspension. This keeps the 15-day suspension, but again, specifies that that's 15 consecutive days and adds an administrative penalty of not less than $2,000. For a 4th violation under current law, it's a suspension for 90 days. Again, this is specifying 90 consecutive days and imposing an administrative penalty of not less than $3,500. And under current law, 5 violations is a 1-year suspension. In this case, it's changing from a 1-year suspension to revocation of the license and adding an administrative penalty of not less than $5,000.
Is there, so it's a permanent revocation, not revocation for a period of time?
It does not specify the period of time, so that might be something to think about and discuss about whether anyone who's had a license revoked, I don't know if someone who's had a license revoked
They could reapply at some point.
reapply, or if there's anything in current law or rule on that. So let the,
Thank you.
getting the indications or no, that's it. Do you, I don't know if you want to hear it briefly from them.
I know, and I think that they're hearing the questions, so I can
Alright.
respond when we have those witnesses. Thank you.
They are my go-to on these questions. All right, so then next we get to contraband and seizure. Under current law, any cigarettes or other tobacco products that have been sold, offered for sale, or possessed for sale in violation of certain sections are deemed contraband and subject to seizure by the Commissioner of Liquor and Lottery, their agents or employees, Commissioner of Taxes, their folks, or any law enforcement officer of the state. This adds in, first, it adds in tobacco substitutes that have been sold, offered, or possessed in violation, and it adds references to the internet sales ban, which is an existing statute in section 1010, we'll look at next, and section 1013, which is a new section on deceptive products that you'll see coming up as well. So it expands to specifically include tobacco substitutes and expand the scope of what's listed in statute as far as what's contraband. And also clarifying who we mean by commissioner when it's talking about law enforcement officer directed to do so. It just says by the commissioner, but since we have 2 commissioners, it's clarifying that it's either commissioner or either commissioner or Department of Liquor and Lottery. Then this is just a conforming change to refer to items seized, and under current law, it says they shall be destroyed, period. This requires them to be destroyed at the expense of the violator and specifies that disposition must be in compliance with the Agency of Natural Resources Hazardous Waste Management rules. And so you'll probably hear some more about that from some of the stakeholders who can talk to you about what is included in some of the e-cigarettes, the tobacco substitutes, and how they constitute hazardous.
Yeah, we know that they're hazardous waste. Without me referencing going back, does this cover wholesalers and retail?
This is anything that has been sold, offered, or possessed in violation.
Okay, so it's not just
various
sold, okay, not
statutes.
just sold, I mean, are these references going back to wholesalers included?
I don't know that they specifically are, because I'm not sure wholesalers sell or offer in violation. But I don't know. I don't know what happens if you've got
Okay, all right,
a wholesaler in violation. I can't recall frankly what 32 VSA 7786 refers to, and that may be a wholesaler statute, but I'd have to look.
okay.
Mark. So. Which case we might need to include a new reference to this chapter. This also specifies that the fine that in existing law of between 1,000 or not more than 1,000, not less than 500 for someone in possession of contraband applies per item. And then no change to the rest of that. Then we get to internet sales. Internet sales under current law, no person shall cause any of these tobacco-related items ordered online or by phone to be shipped to anyone. And under current law, that's anyone other than a licensed wholesale dealer or retail dealer in this state. This would strike retail dealer except as provided in subdivision 2. And that would specify that the prohibition in subdivision 1 on shipping to someone based on an online sale does not apply to a licensed wholesale dealer. So Vermont licensed wholesale dealer shipping directly to a Vermont licensed retail dealer in this state. So it's really looking at not having a retail dealer be able to order online and sell out of their store without paying taxes or going through any of the rest of the compliance. All right, I think that is the end of the changes to that section, except in the description of separate violation for each shipment. It's adding additional items to the list that reflect the ban. So it's really just some cleanup there. New section, section 1013. So not every section in the tobacco statutes chapter is being amended. That's why we're skipping over some of them with these asterisks. But 1013 is a new section prohibiting with prohibitions on deceptive tobacco products and tobacco substitutes. This would prohibit any person from marketing, promoting, labeling, branding, advertising, distributing, possessing for sale, offering for sale, or selling a tobacco product or tobacco substitute by first imitating a product that is not a tobacco product or tobacco substitute, including a food or brand of food commonly marketed to minors, including candy, desserts, cereal, and beverages, school supplies commonly used by minors, including erasers, highlighters, pens, and pencils, portable devices, including smartphones, smartwatches, video games or video game consoles, and inhalers, and a product based on or depicting a character, personality, or symbol known to appeal to minors, including a celebrity, character in comic book, movie, TV show, or video game, or a mythical creature. So that was all part of this imitating a product, tobacco product or tobacco substitute. Also, no person shall do any of these activities with respect to a tobacco product or tobacco substitute by concealing the nature of the tobacco product or tobacco substitute, or by using terms for describing or depicting a product described in this list in subdivision 1. And then it has enforcement provisions saying, in addition to or in lieu of any other civil or criminal remedy provided by law, upon a determination that a person has violated this section, the Attorney General may impose a civil penalty in an amount not to exceed $5,000 for each violation. And for purposes of this subsection, each instance of marketing, promoting, labeling, branding, advertising, distributing, possessing for sale, offering for sale, or selling a deceptive item would constitute a separate violation. In any action brought under this section, the state would be entitled to recover the cost of the investigation, of expert witness fees, and of the action itself, and reasonable attorney's fees. It also specifies that a person who violates this section commits an unfair and deceptive trade practice in commerce in violation of the Consumer Protection Act. And in addition, it gives the Attorney General the same authority as provided under the Consumer Protection Act. Section 2 is a conforming change in Title 4 around the jurisdiction of the Judicial Bureau to reflect the modifications to 7 VSA Section 1005, which now relates only to misrepresentation of age by a person under 21 to purchase tobacco products, not possession and procurement. Section 3 amends 7 VSA Section 210. These are some more general provisions applicable to the Department of Liquor and Lottery. And this is to some extent, some cleanup language or conforming language to reflect changes made in the first section of the bill. So this is talking about who, with respect to a license or permit granted under this section, can revoke or suspend it. And so it's first clarifying that it's the control commissioners, I believe, relate only to liquor. So that's why it adds as applicable, or the Board of Liquor and Lottery has the existing power to suspend or revoke a permit or license if somebody violates any provision of the title or their license, and then makes some changes relating to the tobacco license to allow the tobacco license provisions mainly to be addressed in Chapter 40, where we were looking before. So striking language saying a tobacco license may not be suspended or revoked for a first-time violation, although that is not what happens in Chapter 40 anyway. And then adding in, or explicitly adding in, the authority of the Board of Liquor and Lottery to impose an administrative penalty up to $7,500 against a holder of a tobacco license in addition to these other licenses that they issue for violation of the conditions of the license or this title or any board rule. And then it strikes a couple of provisions, one relating specifically to tobacco licenses. This, just to avoid confusion, under current law, the board may also impose an administrative penalty against a holder of a tobacco license of up to $250 for a first violation and up to $2,500 for subsequent violations. Those numbers don't line up with what we were just looking at in Chapter 40, so let's strike those provisions and let the Chapter 40 provisions govern.
Can I just ask a question? What is a court of competent jurisdiction?
It just means it's the appropriate court so the court has the relevant jurisdiction under law to be hearing.
I just wonder if there's any such thing as court of incompetent jurisdiction.
I wouldn't say it that way, but I think, for example, the licensee wouldn't be convicted in probate court. That would not be a court of competent jurisdiction to rule on a matter like this.
I just never heard that term before.
Yes. I would advise against telling a court where jurisdiction is incompetent.
Mismatched.
And then this would also strike language under existing law that says that for a first violation during a tobacco or alcohol compliance check during any 3-year period, the licensee or permittee would receive a warning and be required to attend a division server training class. And the department can tell you more about this, but I think it doesn't necessarily align with their current approach to education for licensees. All right, now we are moving on Section 4 to the tax statutes. And under current law, the Commissioner of Taxes, that's who the commissioner here is, may, in their discretion, subject to conditions and requirements that the Commissioner of Taxes provides, including any IRS confidentiality requirements, disclose, return information to various parties. This would add in that they can disclose a return information to the Department of Liquor and Lottery if the return or information is for purposes of investigating potential violations of and enforcing 7 VSA Chapter 40, which is the tobacco chapter. Section 5 makes some changes to the definition of cigarette for the tobacco taxes chapter in Title 32 in the tax statutes. I don't believe this has a substantive change in how this definition has been applied in Vermont, but it does align with the definition in Title 33, which is where the master settlement agreement language is and aligns with the master settlement agreement language itself. So in order to be consistent with our definition when we're defining cigarette, this would add language specifying that cigarette is a product that contains nicotine, is intended to be burned or heated under ordinary conditions of use, and consists of or contains, and then it keeps the existing language around any roll of tobacco wrapped in paper or a substance not containing tobacco, and adding tobacco in any form that is functional in the product, which, because of its appearance, the type of tobacco used in the filler, or its packaging and labeling, is likely to be offered to or purchased by consumers as a cigarette, and then goes back to existing statute describing any roll of tobacco wrapped in substance containing tobacco that, because of its appearance, type of tobacco used, or packaging or labeling, and is likely to be offered to, purchased by consumers as a cigarette. Then we have some changes to the definitions of licensed wholesale dealer, which are retained in here, but also starting in 2027 would refer to somebody who is being licensed under the provisions of the new section in Title 7. So you'll see some conforming changes like that coming up. And then in the definition of other tobacco products, these are some of the provisions that were added to the description of the definition of tobacco substitute as different ways that people may be ingesting tobacco or nicotine. So that includes inhaling, sucking, absorbing, or consuming in any other manner. So just trying to maintain consistency with the definition, even as the terminology used in the different chapters is different because of the way the tobacco taxes are applied. And then we have the wholesale dealer. So again, keeping these definitions, but where appropriate, referring to Title VII or otherwise just trying to make the language a little bit more modernized. Sections 6, 7, 8, and 9 are more conforming changes relating to the movement of the wholesaler provisions to Title VII. So first, licensed wholesale dealer within the meaning of 7 VSA Chapter 40. They're subject to provisions. There is one section that will remain in the tag statutes on wholesale dealers. You'll see in a moment having to do with their bonding requirement. And so we're now referring to both chapters. And subchapter 2 is everything else is coming out of it. That's the wholesaler chapter in the tax statutes. And I moved the one section to come earlier in that chapter. So it's being recodified. Section 7, again, is just a reference to the fact, recognizing the fact that these statutes are all going to be repealed here in Section 9. And then redesignating that one existing section on bonding in Section 8 to come earlier in the tax chapter, tobacco tax chapter. Section 9 does the repeals, and you'll see in the effective dates that these are all July 1st, 2027. Section 10 was deleted in the bill as it came out of the Senate, so we left that deletion. Section 11 has a couple of reports, or a report with a couple of aspects. This would direct the Department of Taxes in collaboration with the Department of Liquor and Lottery and the Office of the Attorney General, and in consultation with wholesale dealers and other interested stakeholders, directs them to identify efficient and effective processes by which to impose taxes on tobacco substitutes based on the concentration of nicotine they contain, which was something that the bill as introduced had tried to do, and there were some concerns about it. So it was pulled back to a study for now, and you'll hear different perspectives on that. And also to evaluate the continued use of tax stamps as evidence of payment of the excise tax on cigarettes, little cigars, and roll your own tobacco in Vermont, and look at the pros and cons of different approaches to certify tax compliance. There was some concern in one of the Senate committees in particular that maybe tax stamps is an outdated way of doing things and we should look at alternatives. This would then direct that by January 15th of 2027, the tax department provide its findings and recommendations for taxing tobacco substitutes based on nicotine concentration and on the continued use of tax stamps, including proposed next steps and legislative needs to this committee, various other committees in the House and Senate. Finally, we have the effective dates. The act would take effect on July 1st of this year, except all of the wholesaler provisions moving to Department of Liquor and Lottery would take effect on July 1st, 2027. The vote out of Commerce, to the extent it's of interest, was 11-0-0, although there was hope that this committee would continue to look at the confiscation issue.
Thank you, Jen. Thank you very much. So, one of the things I'm just trying to refresh my memory on is when they were talking about taxation, where is it? On tobacco substitute products. It was
How
implied.
come they're not listed? Is that your question?
Pardon me?
How come they're not listed? Is that?
No, I was just, it was implying that they're not taxed now.
So they are taxed now, but they are not taxed by using tax stamps. They are taxed at 92% of the wholesale price
Okay,
as other tobacco products. So that's why we were making those changes in the definition of other tobacco products for the tax statutes, because that's where tobacco substitutes fall.
okay, that's helpful because
Yes, so they are taxed.
previous legislation, we started taxing them.
Yes,
Okay.
yes, they are taxed. There was interest in potentially looking at taxing them based on nicotine concentration
right, okay.
and on having tax stamps applied. So there would be proof of tax compliance. Those provisions were moved to the study piece in the Senate, but they were in the bill as introduced.
Okay, all right, thank you. Are there any other questions for Jen? We're gonna have a lot of questions for you as we move through the bill, but.
Great, look forward to working with you on it.
Yeah, okay, that sounds great. So for people sitting around the room, if you are interested in testifying on this bill, if you wouldn't mind sending me an email, I'd appreciate it, because we're having substitute committee assistants, and I don't want to put that all on Daphne or all on Linda, who's our afternoon substitute. So please email me with a copy to Lori Morse. That would be great. And just so you know, we will probably start to take testimony on this next week and the week after. So thank you all for being here, and thank you very much, Jen. Appreciate it. Okay, folks, we are back after the floor, I believe. Yes, we are. We are going to continue our discussion on S-157 and act relating to recovery residents certification. We'll be doing some markup on that bill. And at 3 p.m., we have Susan Aronoff here, who's a policy analyst with the Vermont DD Council. And she's going to be giving us her thoughts on S-193, which is an act relating to establishing a forensic facility, another, hot button. I know.
Another one.
I know. It's like end of session is all of a sudden becoming very busy. So, okay. Thank you all. We'll see you back after